Okay, we're going to begin, and we'll pick up on some of the questions that you raised on copyright. So there was a question about school use exception, and I went through the Korean law provision, but I did that in a rush toward the end of a lecture. So we're going to look at it carefully this time. Since we are in Korea, we're going to use Korean law as the text. Okay. So I gave you the copyright law of Korea for you to read, this one. And if you look at Article 25, a work already made public may be reproduced in textbooks to the extent deemed necessary for the purpose of education in high schools and the equivalents or lower level schools. So for high school textbooks, if you are the author of a high school textbook, you can basically take whatever other people's works and reproduce that in your textbooks. So it's okay to copy there. Okay? And paragraph 2 says, schools established by special acts, blah, blah, blah. These are all educational, this is a list of educational institutions in Korea. And it says, all those institutions, educational institutions, may reproduce, distribute, perform in public display, or publicly transmit part of the works already made public, well, it is recognized as necessary for the lessons and for the purpose of support thereof. So, all the schools, including schools under Higher Education Act. What is higher education? Is this high school education? No, this is college, right? So even colleges can make copies of other people's works, without paying royalties, without getting the original author's consent, for the purposes of giving lessons. So this is a little bit different a little bit narrower than purpose of education. This has to be directly related for giving lessons, giving lectures. Okay. Here it says the works already made public. What's meant by the works already made public? Well, whatever book that has been published once, then it's made public. Then it's already made public. Okay, so all that this phrase, the works already made public, requires is that the works that have not been published yet by the original author cannot be used by schools for lesson giving purposes. Okay. Now, paragraph 3 is what applies to you. Read it for me. Read aloud. Those, please, together. Those who receive education at an educational institution. Okay, if this is too, there we go. Those who receive education at an educational institution provided for in paragraph 2, this is all education institutions, including colleges, may reproduce or forward the works made public. Forward is translation of uploading. Okay. Upload online. The works made public within the extent of paragraph 2, well, it is recognized as necessary for the purpose of education. Okay? So, the students, paragraph 3, allows students to copy whatever they want as long as it is necessary for purpose of education. But if you look at paragraph 4, any person who intends to utilize the work pursuant to paragraphs 1 and 2, okay, 1 and 2, shall pay the relevant holder of author's property right the compensation money according to the standards stipulated and announced by the Minister of Culture, provided that the reproduction, distribution, public performance, broadcasting, or forwarding is uploading, of a work under paragraph 2 is done at high schools, their equivalents or lower level schools, no compensation shall be paid. So the total effect of paragraph 4 is that college students can make use of this copyright exception only if the schools pay the fees fixed by the government. Now, high school students or lower, they can do whatever they want. So if you see high school students copying their textbooks or copying the materials for school education, don't tell them that they are violating any law. They are not. Okay? Doesn't matter whether the high school that they go to has paid any fee to the government. Okay? So this is where I told you. This is where I told you you should ask a question whether Korea University has the fee to the government, authorizing you to copy whatever you want for educational purposes, but our school has not done that. Okay, so no exception for you. Okay. Now, I mean, we did talk about this. We just didn't look at the provisions carefully. So I'm showing you the provisions now. Okay. All right. And there is another exception that you should be familiar with. So these are all exceptions to copyright. I mean, I'm showing you all these exceptions to let you know that copyright is not just about giving monopolies to the authors and compensating them. It's about promoting public interest. What public interest? The public interest in using other people's works without having to ask for permission. The law allows certain free use of other people's creations without permission. So I told you to read from Article 23, right? So look at Article 23, reproduction for judicial proceedings. If you need to make a copy of somebody's work for the purpose of a lawsuit, you don't need copyright permission from the author. Okay? Article 24, political speech. So let's say the president, Obama's speech or Hillary's speech, wherever it's made, it's okay to make copies of that. No copyright violation. Okay? So there is a, why? Because, for Article 23, trial, judicial proceedings are really important events in societies. So to make sure that the judicial proceedings are not hampered by copyright laws, they made this exception. Same thing with the political speech. Political speech represent some of the most important commitments of politicians, commitments to the people that they try to govern. So they're, being able to copy the politicians' messages are also very important for people, and sharing of politicians' messages should not be again hampered by politicians' copyright. That's why we have Article 24. Article 24-2 is the creations, the works made by the government. Here, a work produced on business and already made public by the state or local government, or work of which the author's property right is owned in its entirety by the state or local government under a contract, may be used without permission. Okay? Which means that governments cannot own copyright. Does it make sense that government agencies cannot own copyright? What's the purpose of copyright? If at all, it is to compensate the authors, but the government agencies, they already, because they are governments, they have incentives to create more. So governments don't need to be compensated. That's why we have this exception, Article 24-2, for the works created by the government. So you are free to copy the works created by the government. We talked about Article 25, used for purpose of school education. Article 26 is for current news reporting. In case of reporting current events by means of broadcasting, newspapers, or by other means, it shall be permissible to reproduce, distribute, perform publicly, blah, blah, blah. Okay, this happens in like, let me see, let's say there's a news about, do you know Yana Kim? Figure skater? Let's say there's a news about Yana winning gold medal somewhere. And there is, of course, footage of her, circling on the ice. And there will be background music, right? If you're really technical about it, the background music to Yana's figure skating is also copyrighted works. So the news agency or the media agency doing the reporting will have to get permission from the author of the music. This exception allows the news agencies to use the background music or to just play the footage without having to take out the music or getting the permission. Okay? By the way, this is always on, so if you want to ask questions, you can always ask through chatting room. Okay? From time to time, I'll come back to the chatting room and respond to those questions at appropriate moments. Okay? Article 28, works already made public may be quoted for news reporting, criticism, education, research, complying with the fair practice within the reasonable extent. So quotation can be done freely, okay, quoting some works. Article 29, okay, this is important. Public performance and broadcasting for non-profit purposes. It shall be permissible to perform publicly or broadcast a work already made public for non-profit purposes and without receiving any benefits under any pretext in return from audience, spectators, or third persons, provided that the same shall not apply to cases where the stage performers are paid any normal remunerations. Hey, it says, as long as you are performing or broadcasting something for non-profit purposes, you can do it without permission of the author of the work. Who has known about this? What does this mean? It means that if there is a movie that you want to play to your friends, whether it is a pirated copy or not, as long as you do it for a non-profit purposes, you can do it without copyright license. Okay? But you should not charge your friends any money. Okay? And you should not receive any sponsorship, because it says shall not be any benefit from third parties. So let's say there is a festival on campus, and this exciting movie that you want to, show to your friends or see together with your friends. You don't charge any money, you don't charge any admission, and you don't receive any sponsorship from companies. Can you do it? Yes, right? But there has to be absolutely no benefit given to you. That's why you have this exception. The same shall not be applied to cases where the stage performers are paid any normal remuneration. So, perform publicly means showing a movie, but also playing out, actually putting on a play. Okay? Theatrical play or music. Okay? If you play music, if you perform music publicly, then that's also performance. And all of that, right, can be done as long as there is no financial benefit that you draw from such performance. So here, this condition actually is unnecessary, because already it says there shall not be any benefit, right? So if the performers are paid any remunerations, well, then there is benefit. So the exception doesn't apply. Okay? So you go to, say, who has not gone to Myeongdong to buy cosmetics? You all have gone to Myeongdong, right? Hongdae? Yeah? And all the shops are, blaring out music, right? Popular music. Gangnam Style or whatever, right? That's performance, right? That is, it's music that's just on a file or a CD, but by putting on a high volume speaker, It's expanding the physical conditions under which it can be enjoyed, so that more people can enjoy the music. So that's technically copying. That's technically an act that requires copyright license. How are they doing this? Are they doing this? I mean, obviously they're not paying any royalties, right? Are they doing it under Article 29? What do you think? Do you think that Article 29 should apply to Article 29 should apply to those cosmetic shops blaring out music? Yes?
As I know that most of like cosmetic shops and coffee shops using like streaming applications,
Okay.
which you need to pay. So I think that's not any problem.
You are saying that they are paying copyright licenses?
Yeah.
No, they are not. They downloaded the music. They downloaded the music files for personal use, okay, from Melon or some, iTunes. Yes, they downloaded legal files, but that doesn't mean that you can copy them. That doesn't mean that you can perform publicly. I mean, the fact that you can borrow a book from library doesn't mean that you can, make copies of the book you borrowed, or, blow up the pages of the books so that many people can see, right? The fact that they downloaded legal copies doesn't mean that they have license to copy more or play for the audience, right? So there's got to be some other exception. Yes, you're first.
They're not broadcasting it there, right? They're just listening to that music, playing it out loud. So I don't think that is a copyright.
No, but
Just playing it with a big speaker there.
well, big speakers expand the number of people who can listen to the music, right? And in the first class on copyright, I told you that it's not just reproduction that is copying, right? In the sense of copyright. Any other act of expanding the number of people who can enjoy the work simultaneously, right? Whether it's photocopying something, whether it's blowing up the size, or whether it is playing out the script, or sheet music, it all falls under the act of copying, and therefore requires license. Yes?
Yeah, I think it's technically still broadcasting for non-profit purposes.
Exactly.
Because they're not charging for the music.
You are right in the neighborhood, but wrong. But you are right on point. You should ask whether it is for non-profit purpose, and it's not. Okay? So there has to be another exception, right? I mean, the shops, they are playing music. Why do you think they are playing music? And especially usually dance music. It's usually high beat dance music. And there have been studies done that those types of music, push you to buy more. If you go to a department store, they play different kind of music. And the two things that do not exist in the department stores. Do you know what they are? Windows. Because windows distract the customers who should be paying attention only to the goods at the department store. What's the second thing? Clocks. There's no there's no clock on the wall. They don't want you to schedule your time. All right? Also, the kind of music that they select is very ambient, slow, easy listening kind of music. Because at department stores, you have to buy, expensive things. So they want you to relax and take more time. So department stores are also using the background music for profit purposes. So this Article 29, paragraph 1 doesn't apply. Okay? What other exception can you think of? But I'm going to move on now because the answer is right below. If you read Article 29, paragraph 2, it says, it shall be permissible to reproduce any and play for the general public any commercial music records or cinematographic works if no benefit in return for the relevant public performance is received from audience or spectators. Right? It doesn't have to be non-profit purposes. It can be profit purposes, but as long as there is no benefit received by the store for playing the music, then you don't need a copyright license. The store owner does not need a copyright license. That's why you go to bar. The bars play music too for ambience, right? Restaurants turn their televisions on. Korean restaurants do that. And sports bars, they turn on the big screen TV with the soccer games on, right? All of those are copyrighted material, but they are free to do that as long as it is commercial music records or cinematographic works. Okay? So we are talking about commercially available DVDs or files, right?
What about 노래방?
노래방. Okay. Well, guess. Do you think paragraph 2 applies? No, right? Because they receive money for playing the music, right? So all 노래방s, they pay royalties. Or some 노래방s may not pay, and they are violating law. Okay, so this doesn't cover 노래방. So 노래방s have to pay license fees. Now, how about this beer bars? Wait just for a second. Beer bars, there will be more soccer games coming because World Cup qualifying games are on. Korea beat China early September, I believe. Yeah. And there's another game coming soon. And there will be bars advertising that if people come to their bars, then they can get free beer while watching the soccer game. All right? How about that? Will this cover? Will paragraph 2, Article 29 cover that use of the soccer game? We are a little bit getting technical, but it doesn't cover the real-time broadcast. That's why it says any commercial music records, okay, or cinematographic works. So it has to be something. It has to be records of something that happened already, all right? So showing live broadcast is not covered by paragraph 2. So if bars do that, they need to pay license to, guess who? FIFA. So when bars do that, FIFA will start sending notices. Will hire Korean law firm or local law firms and send notices to local bars that they should pay licenses if they want to attract customers by showing live games. Right? What they can do is they can show past games. Okay? They can record. I mean, if they record without license, there will be violation there. But if they get a legal copy of games that were played in the past, they can show all they want under 29 paragraph 2. Okay? Yes, you are first.
What if the performance is for like charity purpose?
Okay, what do you think?
Because it's not benefit for us, it's benefits for other people's, it helps other people's.
Okay, so if it's a non-profit purpose, as long as you don't receive any benefit, right, then you are okay under paragraph 1. Not just paragraph 2, but paragraph 1. Paragraph 1 covers all types of copyrighted work. Paragraph 2 applies only to commercially available DVDs, CDs, or music files, or film files. Okay? So, but if you are really doing it for non-profit purposes, then you are covered under paragraph 1. But the thing is, you said you are doing it for charity purpose, right? Is that for fundraising?
Yes.
Okay, if it's for fundraising, then you are receiving benefit. So the whole Article 29 doesn't apply. Okay? I mean, you know, Steve Jobs made iPhone to benefit the whole humanity, but that doesn't mean that he is a charity, right? So if there is a residual benefit, Article 29 doesn't apply. Okay, there was more question. Yes, you are second. Yeah, you are next.
If beer bars will produce past games, it's okay under the second paragraph.
Right.
But later it says if no benefit in return for the relevant public. Like if the bar, even though it reproduces past films, it will get a benefit. Like it will attract customers, so it doesn't not cover.
The benefit in return for playing the music, right? Well, good argument, but at least the current interpretation is that as long as there is no direct exchange between that benefit and playing the music or playing the film, then it's considered.
We can't assume that there's a direct correlation between the film or the music and
Right. How about if I play film in class for you? Would that be copyright violation? Why not? Okay, possibly educational purpose, but I told you, Korea University, right, has not paid a fee to the government, so I'm not free to show movies, right? Any other non-profit? Well, paying tuition, right? And also, the lecture I'm giving to you is in exchange for the tuition you paid, right? If I play some music in the background, it will be a different story. But all the services I'm providing to you are in exchange for the tuition you paid. So I'm worse than a beer bar playing background music, right? Because what I'm doing is, using somebody else's work to give you the services that you are entitled to, give the service that you have purchased. Okay? So, all right, let's not dwell on this too much, but again, copyright or intellectual property is not just geared toward protecting information created by other people, but making sure that information is freely used by other people for good purposes. Okay, Article 30. It shall be permissible for a user to reproduce in private without any commercial purposes a work already made public within the limit of personal, family, or the equivalent use. Okay? So, reproduction for private use. This is why if you download an illegal music file or film file, movie file, as long as you do it only for your own viewing or your family's viewing, it's not copyright violation in Korea. Okay? We talked about this in the first copyright lecture. Okay? So there was about a year ago, a singer named Kim Jang-un bragged on Twitter that he had downloaded a file of the film Taken 3 starring Liam Neeson. You can look it up. You can Google about it. You'll see news about it. Okay? And that was also okay. There was not a copyright violation under Article 30. All right. Article 31, libraries also have copyright exceptions. Okay. That is for these purposes. Okay. For research and study purposes, or for self-preservation, or the books that went out of print. Okay. All right. Okay, good. Reproduction for examination questions. Okay. If I write examinations, I can copy whatever other people's works to give you exams. And believe me, I'll do that for this class. Okay. All right. Article 33, reproduction for visually handicapped. All right. And production for hearing impaired persons. Article 33 and 33-2 both concerned copying for the blind people. Blind people cannot read the books directly, so the books can be turned into, the letters that they can touch. I forgot what's called that.
Bell's letter.
Bells. Yes. And same thing for hearing impaired people. They cannot enjoy the movies the way that we can, because they cannot hear the sounds, right? So there are subtitle services that put into writing the sounds in the background of the film. That's also copying, and that's also considered okay without copyright license. Okay. Article 34, 35, let's see. Okay. Let's just go through the list, and then I'll come back to your questions. Article 34 is temporary sound or video recordings for broadcasting services. This is exception for broadcasting service providers, because there are times that they need to make temporary copies just for a split of seconds to broadcast. And Article 35, now this is an exception only to works of visual art. Here, the holder of the, okay. Let's say I own a painting. Let's say I own painting of some famous artist, right? I own the painting. I don't own the copyright to that painting. So if I want to make a copy of the painting I own, technically I need to get a license from the artist, right? No matter how much money I paid in buying it. Let's say I paid $10 million. I'm still not the owner of the copyright. I mean, usually there is no point in making copies of these paintings. So what you do is you exhibit it, right? You show it to a lot of people, right? Now that is, if you are the owner of, now that's also an act of copying. Technically you need to, technically I need to pay a license fee to the artist. But this article, Article 35, paragraph 1, allows me to show the painting to the public, right, without the authors, without the artist's consent. And also there's exceptions about permanent exhibitions, permanent outdoor exhibitions. I mean, you don't need to remember this, but there are these exceptions. Okay, all right. And paragraph 35-3 is fair use that we spend like 2-3 classes on, and you see the 4-factor test, which I think are not clear to a lot of people. So in place of the 4-factor test, I created my own test, and you should be ready to use my test if you want to do well on your exam on fair use questions. Okay, all right. Okay, I think we can stop there. All right. Questions? Okay, this one is about safe harbor. We're gonna discuss this later. Okay. Patent, trademark, and copyright. Well, I can spend time explaining that to you right now, but then again, it's something that you will learn over the course of the semester. If you still have the 영어, if you still have the question at the end of the semester, ask again. Okay? Because we will talk about trademark, and we will talk about patent. By the way, there will be special lecture. Mark your calendar. October 10th. Okay, October 10th, 4:30 p.m. There will be a special lecture that I host. A professor from University of California, Irvine, will be talking about ethical issues related to patent on human genes or human body parts. Okay, so that will be a good chance to talk about ethical issues relating to patent. But the question now is about patent itself, right? Copyright, patent protects what is useful. Okay. Patent tries to give a monopoly to the inventor. on his or her inventions. Now, copyright is completely different. I told you that what's useful is usually not copyrightable. That's why I made you, stand up, show your attire, to distinguish what's copyrightable and what's not. The chairs, the podiums, the microphones, all these designs are designed to be useful, and they are not subject to copyright. Okay? And trademark is something also totally different. It's about truth in commerce. Doesn't matter whether it's creative, doesn't matter whether it's useful. If you claim something to be your sign, then that's your trademark. Okay? Korea University claimed this picture of a tiger as its sign, then it becomes a trademark. And no one else can use this trademark in advertising for their schools, because Korea University has a monopoly on using this sign, okay, using that symbol as their own. I mean, whenever you see that symbol, it's a sign that it's Korea University that's involved there, right? If it's a book carrying that symbol, it's a sign that Korea University might have produced it, right? So other schools cannot put that symbol on their books and mislead, deceive the users that it is actually product of Korea University. So it's about truth in commercial relationship. Youngwoo, is that good answer for now? What is Youngwoo? Okay, yes? All right. Okay, amount of hops. This is also about intermediary liability. Okay. Plastic surgery. This is a really interesting question. Did you guys all see this? Absolutely amazing question. Let me blow it up for you. All right. That's a very hard question because tattooist, right? Tattoo artists, they claim and they can obtain copyright to what they do on other people's bodies. Okay? Now, can cosmetic surgeons claim what they do to other people's bodies as well? I mean, what they do on other body parts, it's usually functional. It's not, it's hard to call that artistic. It's usually, taking out fat or adding some fat. But as to the face, well, I think that it comes down to whether your face is functional. I mean, we think that one face is much more beautiful than another, but if you think about it, I mean, imagine you are different species. Imagine you are a dog or cow and try to and you are looking at the human race. do they really look that different? Or are the faces designed in the way they are to serve some functions, like car designs, right? 2 eyes, nose, mouth, they all serve certain functions. So, yes?
But what I meant there is like people in Korea, for example, they go to ask for I want to be that singer.
I know, but you have to ask whether that facial look is copyrightable, right? And I'm saying that maybe we discussed how the designs of automobiles are not copyrightable because their designs are dominated by the functional requirements, right? Don't faces also, look the way they do because of the functions that the face serves? Think about it, okay? All right. Church. Well, good question. I think that definitely a performance, and if the churches do not draw any benefit from it, it will be covered under Article 29, paragraph 1. Okay? We looked at it together. So, but then again, here, right? It's for non-profit purposes. It will be much simpler if the churches don't receive any money from the congregation. But all churches receive money from congregation. Not in exchange for the music played, but they do receive, right? But I think that my guess is that the author of the music probably just allows people to use the music. That's my guess. Or all churches are considered non-profit entities. 노율, if someone was to play a piano piece for a charity event, would that be considered a non-profit performance? Well, if it's a charity event where the money is paid right there for the performance, that will not be exempt under Article 29. Okay, so no exemption there. Okay. Hongdae Street singing famous Youngwoo, Hongdae Street singing famous singer's songs, making money out of it. Well, you are talking about busking, right? Well, that's busking. They are receiving money for performance. That's copyright violation. Yeah. So, if the authors won, they can try to stop them from doing it. Songs, music used in amusement parks. What do you think? You can kind of answer this question yourself based on the examples that we talked about so far. This is a profit use, right? The music is played there to create certain ambience, to attract the users. Okay. Mottos like Libertas, Justitia, Veritas fall under trademark category. Mottos are often private enough to the point we can identify institutions by the motto. Well, yes. the Latin phrases, I mean, Samsung means 3 stars in Korean. That's trademark. Libertas, Veritas, if they use it, if somebody claims it, if somebody claims that phrase as their symbol to provide goods and services under that symbol, that becomes a trademark. Omar, well, we talked about this. Students read Article 25, right? I mean, we covered this very point just a few minutes ago. So read Article 25 and see what you get. All right. All right. Taejin. Hey, tattooing a company logo on his face to infringe someone else's trademark, you have to sell similar things. Okay? So if you sell an iPhone with a Samsung mark, then you are violating Samsung's trademark. If you are selling pizza under Samsung, under the name Samsung, then you are not infringing on Samsung's trademark, because nobody will be confused about Samsung pizza, right? Nobody will be confused that Samsung pizza might have come from the smartphone maker, right? So there is no copyright violation there in tattooing some company's logo. Music covers in YouTube. I don't know what's meant by music covers. If you are talking about music files, music video files on YouTube, yes?
Covering music mean, like, for example, if you are original singer of some music, like let's say, if I sing that song.
Oh, I see. Okay. Well, that's also. What do you think? We talked about similar example in 2 classes ago. Remember the 5-year-old girl singing someone else's song? Technically, it's copying, okay? Because by singing the song, you are performing someone else's work, right? And then you, by making a recording, you are actually copying the tune, melody, beat, right? So that's technically copying, but you should check whether it qualifies under fair use, right? Because remember the 4-year-old girl, the footage of 4-year-old girl, that was considered fair use, not copyright violation, right? So it is whether the manner of your singing was so different from the original work that you can say it is a whole another creation. By the way, all the lectures are coming online on the OpenCourseWare website one by one. So the lecture that I mentioned just now will also come online probably this week. Okay. All right. Hey, you guys have so many questions. All right. Well, we can ask. Well, let's see what we can do. All right. Well, good question. the singer downloading illegal copy of the film Taken 3, yes, it's American work, but we also talked about this in the last class. Remember Berne Convention? Write this down, because I'm not going to give you a separate link or another resources, another reading for this. Berne Convention is a treaty whereby all the major countries promise to enforce foreign works under their copyright law, right? Now, where did the copying take place when the singer downloaded the pirated copy of the film? In Korea, right? So, Korean government is empowered to enforce copyright against that person. But the US government is not, because it happened outside the US. Okay? All right. I think, Hannah, I think I answered your question already when someone asked about music covers. Okay, Hannah, where are you? Okay, it's already answered, right? In answering the question about music covers, right? Yeah, good? All right. Well, here, okay, well, you can read the question yourself. The amusement park, yeah, you're right. Amusement park is run for profit purposes, so Article 29, paragraph 1 doesn't apply. But paragraph 2 may apply if they are playing, music CD or film files. You are right. But for amusement park, okay, this is important. Pay attention. As to Article 29, paragraph 2, it shall be permissible to reproduce, play for the general public any commercial music records or cinematographic works if no benefit in return for the relevant public performances received from audience or spectators, provided the same shall not apply to cases prescribed by the presidential decree. And presidential decree makes exception to this exception and says big facilities like amusement park or department stores cannot benefit from this exception. So only the small size shops, they can benefit from Article 29, paragraph 2 exception. So amusement park can be answered in that way. All right, let's stop receiving questions other than these two. Okay, Lobsang, what's the question here?
Like the architects, they designed the building.
Mm-hmm.
So like if someone copied the same design, so is it like copyright violation?
Well, you should ask whether house designs are copyrightable. What do you think? Actually, let me show you this. Okay, well, Ye-chan, I think Ye-chan answered your question. Houses serve certain functions, right? Yes, I know that there are some, better looking houses than others serving the same functions, but even that difference is dominated by the functions that they serve, right? So usually house designs are not copyrightable. Now, so let me just show you this. Okay, let me see. Okay, this is a Batman Forever. The opening scene. This is the real building that exists in Los Angeles. And then there is a small, it's not a sculpture, but it is some art piece supposedly made in some synchronicity with the design of the building. Okay. Do you see the round top with a column in the center? Okay. So, and this is a real building. So the architect sued Warner Brothers, the maker of Batman series, for copyright, for showing that split of a second. Well, and the whole building, so more seconds than a split. The court said architectural designs are like car designs. They are dominated by functions, so no copyright exists there. Having said that, this is a harshly criticized decision. This is harshly criticized for favoring Hollywood, because American judges very often become target of criticisms that they are too generous to actors, actresses, and celebrities. And some people point this to as one example of being overly generous, because if you look at the building and look at the art piece, there is really no functional relationship between the building and the art piece. The art piece really stands separately and distant from the main building. I can show you the actual building. Okay, it's not this one. It's, okay. Here we go. So this is the building, and this is the art piece. And there is really no function other than being looked at that's being served by this structure. So if I were the judge, I would say that, you know, just like the paintings on your T-shirts, they are separable. They are separable from the functions and should be protected by copyright. Okay, how about building? What do you think? Building somebody else's building, right? Well, there is a special provision about copying someone else's building with another building, but it's pretty exceptional. So it's not really about information society. So, well, it is about information. Well, let's. I'll take this. I'll answer this later. Okay. Golden Gate Bridge, Lotte Super Tower, these are typically buildings that are not protected by copyright. And feel free to take pictures of that, put on Facebook, put on Twitter. Even feel free to make copies and sell them if you want. These are typically functional structures that happen to look good, and there is no copyright protection. Yes?
What about copying them in real life? For example, like instead of like ancient decu, they put like cooking decu.
Building actual buildings identically, right? I'll answer that on this chat room later. You are asking the same question that we talked about a minute ago. Okay. This one, I don't understand the question, but I'll get to them later. Well, my original plan was just to show up the copyright a little bit and then go to the intermediary liability, but you guys had so many questions about copyright, so spent the whole class answering the questions. So let's do it this way. I'll put online material about defamation this afternoon. Read that, and then we'll do intermediate liability next week. Okay? If you did the reading for intermediate liability, that's good. You know, you don't have to do it again, but we'll do that next week. This Thursday, we'll discuss defamation. Okay, so check Blackboard tonight, because I'll put more material in a couple hours. Now, remember that all of you will be asked to sign consent forms for the use of your image. Okay? If you feel free not to sign it, right? If you don't want to sign it, don't sign it. But if you don't sign it, I'll assume that you will not raise your hands, because if you raise your hands, you will be video recorded. Okay? So if you want to raise your hands and it's okay to be video recorded, that's fine. But otherwise, we will need the consent forms to be signed by everybody. Okay? All right, thank you. See you later.